will have two parts. Questions 1 and 2 are bar-style essay questions, and here we've talked about kind of this generally. I'll talk a little bit about what's on here, but then what that means as well. So what it says on here is that points in these questions and relevance, and applying those rules questions. These questions are 1 hour to complete. In other words, the 2 questions should take you a total of 1 hour to complete. And hopefully the takeaway for you from number 4 is it gives you a sense of what you ought to be focused on to these questions. So, and when I sit down to grade bar-style questions, they're kind of easy for me to grade in the sense that I'll have a rubric that I've written out beforehand that will list the rules that I expect you to apply or state, and then also just a brief sense of what that application of the rule might look like. And those are the only places where you will get points, which means that you will get points for spotting issues, knowing what issues matter in deciding the admissibility of the evidence in question, and then in your ability to apply that rule to the facts. And a good application of the rule to the facts needs to be something more than a conclusory statement that an element of a rule was or was not met. It needs to include a citation to some fact or facts that explain why the element of the rule was or was not met. So we'll see, hopefully we'll talk through some of the bar-style questions from past exams to what that means. But that hopefully gives you some idea of what I'm looking for, and frankly, the brevity of the answers that you can provide, or you should provide. And it also should give you a sense of perhaps categories of things you don't need to include. So you don't need to include broad statements of the hearsay rules were meant to ensure the reliability of evidence. True, but not specifically admissibility of a particular piece of evidence. All right. And so anyway, so question 3 then will be a law school style essay question. And I'll read this, and then we can talk about what this means for you. Your grade on this question will be determined demonstrates an understanding of the law and policy issues discussed relate to the factual scenario set forth in the question. By your ability to, among other things, identify relevant issues and facts, identify valid arguments on both sides of an issue, evaluate the relative strength of those arguments, apply the policies underlying the legal rules in a relevant manner, and express yourself in a clear, organized, and succinct way. This question is meant to be completed in 2.5 hours, with approximately the same amount of time being devoted to each of the question, as will be indicated on number 6. So what this means as a practical matter from my standpoint is that when I grade your answer to law school style essay questions, these 2 parts, I will first grade question 3 part A. That means I'll go through everybody's exam and grade that, and then I'll grade everybody's exam question 3 part B. And as I do, I will be trying to assign a number on a scale of 1 to 10 to my sense of your understanding of the materials that that question asks you to discuss. And there's a lot that goes into that, obviously, and I've tried to articulate some idea of what goes into that assessment of your understanding, right? What hopefully you can take away from that list of things is it is in some sense everything that suggests understanding of what we talked about in class, but it's all the stuff that you're expected to do as a lawyer, and also hopefully we've done here in class as we've gone through the material and the problems and everything, right? So it includes like identifying relevant issues and legal rules, applying those rules to the facts. But where we perhaps go beyond what is in a bar-style question is I identify valid arguments on both sides of an issue. I need to be able to evaluate the relative strength of arguments on either side of an issue. I want you to see or to know when under. So in other words, when an answer is not proven simply by applying the language of the rule, I want you to see that and to be able to apply the policies for why the rules exist as they do to help try to answer those questions. And I want you to be able to do it in a way that makes sense. That's all I mean by express yourself in a clear, organized, and succinct fashion. That doesn't mean you need to write in perfect grammatically correct English. It does mean you have to write English, because that's the only language I can grade. But it doesn't mean you have to be perfect. Doesn't mean anything has to be correctly. Doesn't mean that I'm going to be taking off points, dangling prepositions or anything like that. But you got to give some thought to making sure that you're structuring your answer in a way that enhances its readability and enhances understand the material. Okay. So law school style essay distinction. All right. I want to record that explanation of it, and then I will just play it back for future classes. If this was so perfect, then you all get it. 4 viewers. All right, everybody. Best behavior. Public stream watching. Available on the exam. I appreciate that this exam is worth 8. All I is I will determine how many points you get out of 7, and then multiply that by 8/7, and that will then provide points out of 80 that you will get, which I will then add to the points the number of correct multiple choice questions you answered on the midterm, which will itself be words to provide a number out of 20. Final exam. I appreciate that in fact, that is worth 80% of your grade. That is not lost trust. I can figure out this complex mathematical equations. So distributed as set forth. Question 1 will be the point distribution. Questions, you ought to expect to spend 15 minutes, 25-point questions. Hopefully what you also notice is that this adds up to less than 4 hours, even though you have 4 hours on the exam. My goal is 1.5 hours. I am incapable of writing exams that take as long as I think they're going to take. Legal room so that hopefully time pressure is not the main thing. Any performance issues that you might have on the exam. My goal is for you is not fun for me, and it's certainly please handwriting your exam something like foolish so that I can't figure out which blue book leads into which one. That's all that means. If you not, oh, who's right there? Look, it's Jeff, but don't go talk to him directly. Have your proctor do that. And then if you have questions during the exam, the proctor, who will then speak to me, please don't just wander by my office there. It's Saturday morning. But B, I wouldn't be able to answer your questions anyway unless. Number 11, please don't violate the honor code. Everything into the exam. And then number 12, exam. Questions? Yeah.
This is so you're providing us obviously with the rules, and so they're not going to have like the advisory committee notes. So they at least going to have like the numbers for the rules themselves.
Yes, they will be listed by number, and they will include also the subsections. I won't just provide just the text. Yes. Yeah.
In addition to being streamed, will a copy of it be on Twin?
A copy of this? Yes, it will. We'll watch that. No? Wow. All right, great. Well, if they come up, if you think of them during the review session, or feel free to email me about them afterwards or anything like that. Like I said, this is up on Twin, so feel free to look at our review session, which is where you ask me questions dealing with. Any questions? Where's that? Of showing that they don't understand. Oh, come now. Here's the thing: I'm not going to meet with all of you before exam time. Won't. So please, questions if you have them. Nobody wants to. Yeah, Vondell, you did. So I was waiting for you to ask. Good. No, you told me beforehand. She told me beforehand. Yes, go ahead.
It's dealing with rule 401 and the materiality is that does the fact matter to the case? Now, are we talking about the fact that we're trying to prove or the evidence that we're trying to get in is trying to prove the fact?
We're talking. Thinking about relevance. The first question is, what fact is the evidence trying to prove? And sometimes that can be pretty obvious, sometimes it can be a little less so. Oftentimes, as attorney, you'll want to be able to. How is that fact relevant to the case? Sometimes it's easy. Sometimes that fact will just be an element of the charge or the claim or a defense or something like that. And sometimes you just need to kind of draw the line from that fact all the way to an element of the charge or of the claim or of a defense. Yes, Jeff. Oh, okay, yeah. Excellent. That last question was whether or not materiality under Rule 401 was showing that the evidence was relevant to the showing that the fact proven by the evidence of the case. The answer is the latter. I should also let you know that you can ask questions if you are watching online. Online. You can too if you're watching online easily. So. Yes.
Okay, this one is about.
If you have questions, all questions.
This is about Rule 412.
Mm-hmm.
And it was saying that I can use evidence that the alleged victim has had sex or whatever with someone else to prove that someone other than the accused. So my question is, do I have to know for sure that there was definitely another person that they had sex with, or that there could have been another person they had sex with? And then how is that different than introducing their promiscuous behavior?
So I think I understand your question. I think I understand it to be sort of what standard of proof must a person who's offering evidence under 412, the first exception, establish that the victim in the case, in fact, behavior with someone else. Okay. And I think the answer is it's a relevance standard that applies. So the evidence has to have any tendency to establish that the sexual behavior with someone else happened. I don't think that the evidence doesn't need to prove at a particular level. It just has to have some tendency. what that evidence goes to prove is it goes to prove something that is okay under the rules. So, no matter your predisposition. However, if the of the victim's sexual behavior is sexual behavior with a you guys just all came to watch through the spring 2015 exam? All right. As we go, based on discuss from spring 2000, we should talk. So, question one, and I know I still think, though, our discussion in class can be useful because as opposed to just kind of answering specific questions about which rule applies and things like that, I want us to be thinking about how we tackle problems like this and then what should actually go into your answer as you answer these questions. Okay, so ultimately, really boil down to it, all a bar-style essay question is an exercise in issue spotting, followed by remembering what rule, and then a pretty straightforward exercise in legal analysis. But the first part is going to be issue spotting. And it's going to be, as you go through reading each question, being able to identify issues that might occur somewhere in the analysis, but the issues are really going to determine whether evidence is admitted or not, or whether objections are upheld or not. And that's what I want you to be focusing on as you go through bar-style questions. Excuse me. I will note, particularly in evidence questions and these bar-style questions, you might well gain a lot by starting from the end and looking at what question is asked. Because as something like question one, if you went down to the end, you'd read, the opposing party lodged hearsay objections to each listed piece of evidence. How should the court resolve these objections? This tells you what area of law you're going to be thinking about and discussing. So what it should tell you is get everything else, because I don't want authentication. I don't want to hear objections about character evidence. I don't want to hear objections about Rule 403. These are hearsay objections. And that's all you need to be thinking about as you read through. Okay? So with that in mind, give it a read and make a note. And I would say limit yourself to one or two issues that you think should be discussed in answering each question. And you at home do the same. All right. Good. Everybody a chance to read it? Think about it briefly? Excellent. Good. So, first question. What should we be talking about? As in question 1, part 1. What should we talk about in our answer? I know, you're like, I thought this was a review session where you tell me stuff, not one where I tell you anything. It's okay. Yeah, Ashley? Okay, so you could start with, as generally try and answer the question of, is this hearsay? Okay, so a couple words on that analysis. I gave you 5 questions that you should think about whenever you, in trying to decide whether a piece of evidence is or is not hearsay. When going through the analysis of whether evidence is or is not hearsay on an exam, you do not need to go through those 5 questions. What you need to do is you need to explain to me whether or not something is hearsay. And answering those questions is helpful to you. That's the reason I put them together and suggested that you think about them. But in some sense, that's kind of should be a starting point for your own internal mental analysis of the issue. But it's okay if you go through them. It's just probably more time consuming than getting to the nub of the issue, which is, do we have a statement? As in, do we have an attempt to communicate a fact to an audience? And if so, is the statement being offered to prove what the declarant was asserting? Okay, so those are really the 2 questions that are the, kind of the crux of the hearsay analysis. Kelly?
So if we find that it is hearsay, would you at least like for us to say it is hearsay because, or just keep it simple, it is hearsay?
Well, it kind of depends. So it depends on whether the evidence being hearsay is non-obvious and matters for the admissibility of the evidence. So here, is this hearsay? Some sort of recognition of my question would be much appreciated. Is this hearsay? Does anybody think it's not hearsay? Okay. Well, you guys are wrong. Since, after all, what he's asserting, at least in part, is I didn't see or hear anything before boom. And that needs to be true in order for this to be evidence to prove that the warning lights and bells were not working prior to the collision. All right? So it is hearsay. And hopefully, at the end of the day, in most of these cases, that sort of thing is straightforward. So you can mention it, but in a case like this, that's not really going to be what determines whether, or it determines whether the evidence is admissible or not, but it should be pretty obvious to you. Okay? Which means, no, you don't actually need to go into the analysis on this question at the end of the day. Rather, what is the crux of whether this evidence comes in is whether any hearsay exception applies to this evidence. Again, I'm now asking a non-rhetorical question. Does any hearsay exception allow this evidence to come in? Are you not answering because I need to chide you once more, or is that because you're not sure? If further chiding is required, please raise your hand. If it's because you're not sure, please raise your hand. Okay, see, now we're less sure, right? And it's on those questions that that's where I want your analysis. The ones that are less obvious, or less clear, or less straightforward. Okay? So, in an issue like this where you're like, I don't know if an exception applies or not, your best avenue is to pick an exception that it comes closest. So either the one that actually does apply, if you think one does, or the one that comes closest, and explain to me why it doesn't. So what hearsay exceptions might we discuss here is ones that seem close to applying but don't actually. Okay, 8032, excited utterance. Fair enough. So if, yeah. Okay, 8031, present sense impression. Okay. Good. Anybody else? Any other thoughts? Okay. So I think those are two perfectly valid ones to discuss. And so here's what your answer to a question like this one should very well look like. You probably, starting with a statement, this evidence is here, this testimony is hearsay. The Murphy may argue that this statement was an excited utterance and was admissible as an excited utterance. An excited utterance is a statement. Anybody want to define excited utterance for me? In part because I'm just totally blanking here. Yeah, Russell.
Relating to
Exactly. So an excited utterance is a statement made relating to a startling event or condition made while the declarant is under the stress of excitement caused by that event or condition. Great. There's your rule statement. 1 point. So anybody care to tell me whether or tell me why? Sounds like you think it doesn't apply, or at least some of you think it doesn't apply. Why is this not an excited utterance? Elizabeth? Okay, good. But now connect. So Elizabeth notes it was made a month after the startling event or condition. Connect that back to what the 8032 requires. Tell me why that means 8032 really isn't met. Uh-huh.
When it's under the stress of how it occurred, so this is a month later, I don't feel that you're still be under that stress.
Okay, good. And that's exactly what I want an analysis to look like. Elizabeth said something to the effect of, in order to be an excited utterance, the declarant must still be under the excitement of the startling event or condition. Occurred more than a month earlier, it is unlikely that that excitement continues an entire month-long period. Therefore, likely to be an excitement. That's what I want your answer to look like. Russell?
So, now, correct me if I'm wrong, didn't we say that an excited utterance timeline is not less important, but not as important as maybe a present sense impression timeline?
Absolutely.
The stress, like you said, it's unlikely to have lasted that long, but possibly could last that long.
Sure, right. So Russell raises the point that under 8032 that whether something is an excited utterance is a subjective question. Was this declarant in fact under the stress of excitement of the startling event or condition for the entire period since the relevant event occurred? And sure, the timeline is not determinative in all cases, in that some people simply remain under the stress of excitement of a startling event or condition longer than others. But it's certainly a relevant fact. And here's the thing on these bar style questions, and I say this because in my experience, it's also kind of what the bar is generally looking for. I'm not really looking for like an in-depth analysis of point and counterpoint. I think Russell's point is a perfectly valid one as a kind of a substantive evidence matter. But it's not necessary or really required for you to have a good bar style essay answer. It's okay for you to just apply the test to the facts as they are available, and you don't really need to recognize counter arguments during that analysis. So, Candace?
What is the valid argument to say under 8033 because it mentions the existing state of mind and like includes sensory and you say here to see anything?
But when we mean then existing, what is the then in the then existing state of mind under 8033? Whatever what event was. We have two moments in time right now. We have the moment in time of the crash, and we have the moment in time a month after the collision when he's making this statement. Which then does 8033 talk about?
Okay, so it's referring to when he made this statement?
Exactly. So 8033 only deals with then existing states of mind, as in states of mind that existed in the declarant's head at the moment the declarant made. Here, Murphy is not relating. He is not relating what his sensory impression. Making the statement, he's relating his sensory impressions from a month earlier. 803.3. Frankly, I'd be probably okay with you talking about 803.3 and why 803.3 doesn't apply in this problem as well. Yeah, Marima?
You could also look at maybe 801 D2A and just point out that normally it's like a party when students is admissible, but not when it's not being used against them.
Yes. I mean, I think you could talk about 801 D2A here as well. This is a party statement offered by the party, or sorry, not being offered against the party, it's being offered by the party, so 801 D2A doesn't apply. I think you could talk about that too. I will note, right, so when I write out my draft answers, kind of my rubric to these questions, I do write down something, but if you make a good argument, then I'm willing to give, at a minimum, partial credit and often just full credit for it. I mean, what I'm looking for here is you to try to grapple with some exception that might apply but doesn't. Exception does apply. Now, there'll be some problems where the facts are kind of point more strongly towards a particular exception, and it'd probably be beneficial for you to kind of address that exception if you see that. But don't feel like you are really playing a game of guess what I'm thinking. Try to be playing the game of answering the question correctly. It's a fun game, but it's what we play. Brian, did you have a question? Okay, okay. So hopefully what you note is that, an answer to question number 1 could really be about 4 or 5 sentences long. It might even be able to be shorter than that. So if, you know, and I understand, and kind of let me make clear, I'm fully aware that in these bars, I'm asking you in some ways to do the opposite of what every professor in law school has told you to do up until this point. In the sense that most professors have been like, word diarrhea, bring it on. Say as much as you possibly can in the amount of time I've given to you. All right? But in fact, answering questions in a short period of time is a skill you will need, largely for the bar exam, but also for practice. I mean, being able to succinctly answer questions is also a good thing as a general matter. And so this is something that will take practice. I will not punish you for writing more than you need to write on these questions. If anything, the clock ultimately will do that punishing. But again, that's part of why I give you a little bit of extra time, at least as I consider you need to answer the questions. So that, oh, yeah.
Well, okay, so I haven't been paying attention to you.
Oh, good. Okay, great. How many of you also have not been paying attention to me?
I've been trying to figure out where these chats are coming in.
Chats are coming in?
Chats are questions. So there's one, Jennifer Lebeau says, for an answer to a question like this, should we address multiple exceptions, like excited utterance and present sense impression, or just pick one?
Jennifer, thank you for your... No, that's... oh, you can just pick one on something like this. Good. Any others? No? Okay. Joy? Yes. I mean, in some ways, because it does not... you're right. You can answer the question, how should the court resolve these objections, by just going, the objection should be sustained. But that doesn't really tell us much, right? And so I understand that that's a bit of just like a formalistic rule that I'm telling you. But yes, for purposes of this, I would do that. And I will say, for purposes of bar exams on evidence questions, you're going to want to also at least articulate why at least some exception doesn't apply if you ultimately exclude evidence on the basis of it being hearsay. Good. Other questions? All right. Great. Number 2. What exception should we, or what rule, what should we be talking about? Yeah, Abigail? I started by saying what exception, then I caught myself and I said, I'm not going to show my hand like that. I'm going to play coy and just say, what rule should we talk about? Abigail.
8036 business records.
Okay, 8036 business records. So you would agree that this is hearsay? Would everybody agree that this is hearsay? Okay. This should be a relatively straightforward hearsay analysis as well, where you note that the declarant is asserting a potential non-functional warning signal that would be offered to prove that the warning signal was non-functional. Pretty easy matchup there of what is asserted and what it is being offered to prove. So it's definitely hearsay. And Abigail says 8036. Okay, I think that is a possible exception, right? I mean, we're dealing with a record of a business. Other thoughts? Sean? Okay, so a statement of party opponent, specifically the employee of a party opponent. I like that one better. Oh.
Business record exception, what should we disclaim that it doesn't matter that it is a party opponent in this case because it is a civil suit?
Okay, so 801D2 applies to both civil and criminal actions. So the fact that it's a civil suit doesn't change the applicability of 801D2. And in fact, 801D2D is going to be your better answer here. And I'll start by just, actually, Sean, why is this 801D2D?
So there's four things that rule requires that one, the declarant is an employee. Two, the statement is while in an employee relationship. Three, the statement is within the scope of the employment relationship. And four, the statement is offered against the party. And I think all four of those.
Okay, great. So we need four things, and I think that's accurate. The statement needs to be made by an employee of a party. It needs to have been made during the employment relationship. It needs to have been made within the kind of substantive scope of the employment, and it needs to have been offered against the party. So Sean says all four are met. Why? Point us to facts. Just go through each of them.
So Simmons, he's the director of railway safety.
Yep. Mm-hmm. And why is it made within his employee capacity? Okay, well, there's two things. While he is still an employee, so there's a timing issue and there's a substantive issue. So I think the timing one is pretty straightforward. You would say he made the statement while he was in that role working for L&S. How would we answer the substantive issue? How do we know this is within the substantive scope of his employment? But why? I mean, what is the topic of this memo? Well, that's what's being offered to prove. I mean, what is this statement about? Yeah, I mean, but that's what it says. I mean, I'm kind of just, I think it, I mean, what is the statement, what is the general category of the statement, Caroline? Yeah, I mean, I think you could just say something like, this is a memo about an accident that happened to the railway, with the railroad. Therefore, it falls within the purview of a director of railway safety. I mean, that's kind of what I'm looking for. And I mean, that's what it means for something within the scope of employment. I mean, as opposed to him, you know, him or her, our generic Jan, who, you know, perhaps it's, you know, if he said something about the stock value of the company, right? Or profit earning, you know, profit projections. That's not a railway safety issue. And so perhaps 801D2D wouldn't apply. But here we have something that's like easily within the scope of railway safety. And that's all I want to see is just a statement that says this is within the scope of employment because this part of the memo is about an accident on the railway, which touches directly on the issue of railway safety. And then finally, it needs to be offered against them, which we just say it is, right? I mean, there's no fact other than that fact to establish it. Good, so that's what I'd want to see. I like Sean's articulation of 4 different things that need to be met for 801 D2D to be satisfied. And then you just want to step through each of them, making sure you point to facts whenever you can and connecting those facts back to what the rule requires. You have to do more, if possible, than just say this element is met. You have to say this element is met because, and give me a reason that points to a fact. So then that brings us to why would I not want you to discuss this under 8036? And the main reason is I don't think 8036 is satisfied. And so if we're answering trying to determine, kind of point to the rule that is determinative of the admissibility of the evidence, 801 D2D is, and 8036 simply isn't. And the reason I'd say 8036 isn't satisfied, excuse me, is because we don't have testimony provided by a qualified witness to tell us about how these memos are generated and how these memos are kept and whether that is being done in the regular course of business. And so really 8036 isn't satisfied, so it's not a good exception to discuss. Yeah.
Did you talk about why it doesn't, like it's not satisfied by 8036, or you just leave that out?
No, I totally leave that out. I really, want you to focus on the rules that ultimately determine whether the evidence comes in or not. Yeah, sure, then you could. Yeah, right, correct. Yes, if this were law school style, you can talk about it. Okay, good. Other questions on number 2? Yes.
801 D2C.
Uh-huh.
Could that apply to, or could we make an argument for?
I think 801 D2C could as well. I mean, D2D isn't a perfect fit because it's not really clear that the director of railway safety is an employee of the board. It may be in some sense that the director is an authorized spokesperson. I think either one could work. Yeah. Good. All right. Cool. Number 3. Now we're talking about evidence introduced by the defendant. So what are we talking about here? First off, is it hearsay? Yes. Okay, right. Again, pretty clearly hearsay in that it asserts that Alex thought he could outrun the locomotive, being offered to prove that his negligence, not L&S's negligence, caused the collision. Clearly, it has to be true that he was considering outrunning the train for this to be relevant for that purpose. Any exceptions apply? Any exceptions to discuss? Kelly? Okay. Fair enough. 8031. Any others? Sean? 8032. Any others? So, excited utterance, perhaps? Bobby?
Statement under belief of imminent death.
All right, 804B2. I think this could work under any of them, or perhaps could work under any of them. All of them are relevant, and you would want to pick the one that you think is most likely to work. Again, because that is the one that, if it in fact does work, is determinative of the admissibility of the evidence. And also because it's the one, if it doesn't work, is probably the one that's going to be the most in dispute, right? It's the one that's closest to working, all right? So I think we can go through them relatively quickly. 8031, present sense impression, requires that it be a statement about something perceived at or shortly after the declarant perceives the event or condition. Here, he is describing, I suppose, his thoughts shortly after he experienced those thoughts. The downside on this one is we don't really know how much time passed in between the collision and him being pulled from the wreckage, outside of the fact that presumably an ambulance was called and one would think it arrived relatively quickly. So it might work. It's going to be about that timing issue. 8032, excited utterance. We've talked about that a little bit already. Again, the question would just be, Is he still under the stress of excitement of the startling event or condition? We have no specific evidence that he was, how outside, again, of the timing issue and the fact that it was a pretty darn startling event or condition, being hit by a train, so we could imagine that that stress of excitement would last longer. 804B2, dying declaration, we need it to be offered in a civil case or in a homicide prosecution. This is a civil case. And we need it to be a statement about the causes or circumstances of death. This certainly is, in the sense that it's about kind of what caused the train crash. And then it needs to be made under the, what is it, Bobby? What's the impending?
Under the belief of imminent death.
Yes, belief of imminent death. Unclear, right? He does, here our declarant doesn't express, oh, I'm going to die and I thought I could outrun it. However, he also does fall unconscious and soon after and die 3 days later. So from that, we might be able to infer that he was under the shadow of imminent death when he made the statement. All right. So we'd want to go through one of those three questions. Yeah. Okay, so I would say no, because that would need to be a statement of then existing state of mind. But remember that 8033 doesn't apply to facts remembered, or statements of facts remembered for the purpose of proving that fact. And so this, here the past tense is kind of enough to take it out of 8033. He's essentially saying, I remember that I thought I could outrun it. It's being offered to prove that he thought he could outrun it at that time. 8033 doesn't apply. Yeah, Destiny?
What about 804B3?
804 statement against interest. Okay, I mean, sure. Go through that analysis. Do you think?
Well, it just proved that he was negligent in trying to cause the insurance
Mm-hmm.
because he knew the train was coming.
Uh-huh.
So it was his fault that the accident occurred.
Okay, that's true.
And admitting to it would put him.
And so here's one thing I always want you to remember for 804B3. And I've kind of put you on the spot, so it's a little unfair. But 804B3 is more than just prove that this is a statement that is bad for the declarant, right? There is a standard that we need to be thinking about when we try to apply it, right? Which is, it needs to be a statement that is so against the declarant's pecuniary or what's that? Yes, pecuniary or proprietary interest, or so likely to subject the individual to civil or criminal liability that a reasonable person in that position would not make the statement if it were not true. That is a more precise standard than just, is this, as a general matter, a statement that's bad for the declarant. So to the extent that we frame, and I think you're right in the sense we can make the argument that this is an 804B3 statement, but we want to frame it in those terms. As in, we would need to say, this statement was so against his pecuniary interest, or it was so likely to subject him to civil liability because, and explain that, and the circumstances were such that a reasonable person in his position would not have made the statement unless it were true. I mean, that's the operative language of 804B3 that we need to be focused on in our analysis. So in terms of talking about 804B3, just make sure you're thinking about that. Okay. Good. All right, let's look at number 4, and then we'll take a little break so I can take a break. All right, so number 4, hearsay. Yeah, right, hearsay. Again, this is pretty clearly hearsay, since it is being offered to prove that the warning bell and signals at the collision site were operational 2 days before the collision, and the records say that the warning bell, signal, and bells at the collision site were operational 2 days before the collision. I mean, that the statement and what it's being offered to prove match up exactly, so therefore it's hearsay. Yeah, Elizabeth. That's a very good question. Or let's think about this a little bit more. Step back for a sec before we answer that question. what rules should we be talking about here? What issues do we want to discuss? One is kind of who is the declarant? I mean, who is the declarant? But then we also want to be thinking about if it's hearsay, does an exception apply, right? Those are kind of two separate issues, right? And so it's probably worthwhile to talk about both. So start, who is the declarant? What's that? Okay, but a declarant has to be a person. Okay. So, but was no person responsible for the information printed out on the record? Who's the person responsible for that information? Laura? Okay, so the safety engineer who responded to the maintenance request is the one who states that the request is resolved and when it was resolved. The safety engineer is, in other words, the declarant with respect to those two pieces of information. Who's the declarant with respect to the initial report of the malfunction? Bobby?
The locomotive conductor or member of the general public.
Yeah, exactly. Whoever it is who made the report. We don't know in this case anything about the identity of that person. Which declarant do we care about in this problem? Yeah, the safety engineer is the one that we care about, right? Because it's the safety engineer who provided the information that's actually being used in this case. So the safety engineer is our declarant. But hopefully what you would see from reading this is that is a non-obvious understanding of this piece of evidence. Therefore, you would want to talk about it in the answer. There would, and I don't have my rubric in front of me, I'm quite certain there was a point available for talking about how there really are two pieces of information here generated from two different sources. And this is hearsay generated by the safety engineer. Great. What exceptions might we discuss here, or what exception? Kelly?
803.6, the regular conducted activity.
Okay, business record. Good. Others? Anybody have any others? 803.5, recorded recollection. Okay. Any others? All right. Yeah. Oh, wait. Another one over here. So,
Maybe 801D1B, only if it was all in question.
okay. So a prior consistent statement of a witness. Okay. So I'll just kind of talk about the last two. 801D1B. That could work if our safety engineer testified. If the safety engineer who completed the request testified, then 801D1B might work. But we don't have any evidence that he did. We don't know who it is. All right. 803.5, recorded recollection, also doesn't work here. Because remember, the recorded recollection, we just don't have the testimony to go along with it to show that it was, a record made at or near the time that it was known that the person is vouching for here in court to say that it's accurate. And we'd also don't have testimony from the person saying that they're unable to remember it here in court. So we just kind of are lacking those predicate facts for 803.5. 803.6 is rather the better option here. And in some ways, that might be just indicated to you by the nature of the way the problem is written, right? We have somebody who might be a qualified witness to testify about how these records are generated and how they're kept. But ultimately here, what you want to do is you want to lay out 803.6's requirements and explain why they are or are not met. So let's see. Top of my head, oh, yes, question. Ooh. Oh, good. Agreed. So 803.6. Yeah, no, 803.6, business records exception. So first thing we need to know, right, is that we need to know that these records are generated in the regular course of business. And the testimony of Richard seems to suggest that they are kept in the regular course of business. Richard's testimony is not it does not directly on point here, but certainly also suggests the way that they are kept and that it would be part of the regular course of business. What else do we need? Oh, that they're made at or near the time by somebody with knowledge of the underlying fact. Again, at least with respect to the part we care about, we know that it's at or made by a safety engineer at or near the time of the event with knowledge. Good. Anything else?
So to be clear, recorded recollection also requires a witness who needs their memory refreshed.
Yes. Yes, it does. 8035 requires the testimony of a witness who needs their memory not really refreshed, but who testifies that they are unable to recall the event. Okay? So what else do we need for 8036?
At or near by a person with knowledge, regularly conducted business, regularly makes or regularly kept, and trustworthy.
Trustworthy. Is this trustworthy? Or more to the point, is there any evidence that it's not trustworthy? Sean? Yes, you absolutely could make that argument, which is why I at least I was hoping you would, and that's why I included the fact that while the fact that the closing date on which the request is listed as having been resolved is entered manually by the safety engineer assigned to investigate the request. That would therefore allow at least for fabrication in anticipation of litigation. So on this one, as I recall, I believe there were 4 points available for part 4. One for discussion of the fact that there are multiple declarants and which part we're dealing with here, which part is the hearsay we care about. Second, for correct articulation of 8036. A third for an analysis of the first 3 or the first elements of 8036. And then one more for a recognition that there may in fact be some evidence, or at least some argument, of untrustworthiness with respect to this record. Okay. Questions? Yes.
So I know this isn't really a call to question, but could there have been an authentication issue?
Yeah, I mean, certainly, right? Richard would also probably need to testify this, or if he generated the record, whoever got the record there would probably need to testify to its authenticity, that this is a record that came from their system. Probably Richard would do that, but we'd need something like that. So we would need some authentication. Good. Other questions? All right, let's take a couple-minute break. Those of you who wish can now run downstairs with your computer and just start streaming this live from the library instead of being here. start it again. After all, I want to eke quality out of every moment we have together. So let's look at question number 2. Now, of course, note here, right, we have no limitation in our question prompts to what we're going to be thinking about in terms of what rules we are going to be thinking about. Certainly, you could probably guess that hearsay is not going to be the focus of these issues, given the fact that they were the focus of question 1. But if I were you, I also would not like kind of draw a hard line excluding that as being a possible issue. So, all right. So why don't you take a minute or two to look those over and think about what things you would want to discuss in addressing question 2. Just 4, just part 4. Our peak viewership. 5. Ugh. Do they get to give us like star ratings? No. Ugh. All right. So, a few thoughts to begin, right? So here, unlike our prior problem, we have nothing tells us in the prompt of the question or in the question why any of this evidence is being offered, right? And what I told you at the beginning of the course, and tried to reiterate as we went along, was that the first question you need to be asking yourself is, how is this evidence relevant? You should continue to be asking yourself that question, even on bar-style essays. But here's the thing. As a general matter, you don't need to tell me what your answer was. You just need to answer that question for yourself so that you understand why this evidence even matters, because that's going to give you some direction as to the rules that you want to apply, right? But again, you don't need to tell me what your answer is. You don't need to start with saying, the first issue here is, how is this evidence relevant? Because relevance typically is not going to be the issue that gets evidence either admitted or excluded. So think about it, do it in your head, but you don't need to write it down, all right? So that's kind of the first thought. Now, with that in mind, let's look at A, right? How would A be relevant? I mean, why is Sarah calling Anne to testify? What is it meant to prove for her? Kelly?
I think it's 104, 6
Okay, but without getting into, I mean, we will get there, right? But like, how is it relevant? What is she just trying to show?
That Sarah was responsible driver and would not have followed.
Okay, but I think we can even be more precise than that. It's not just that she was a responsible driver in a general sense. Ashley?
Specifically that she would have used her turn signal, which is the crux of the case, is that she didn't use her turn signal to cause the negligence.
Yeah, right. I mean, the argument is, or Sarah's argument would be, this evidence tends to show that Sarah must have used her turn signal prior to changing lanes at the time of the accident. And if that's true, then it makes her much less likely to have been negligent. I mean, that's how this evidence is potentially useful to her. Yeah, Joy?
Is that the only answer?
Well, how else would you say this is relevant?
Okay, well, I was thinking that Sarah said that she's contending that he drove off the road intentionally. She's calling her teenage daughter, maybe her daughter's testifying and speaking to her credibility as like saying that what she said, like she's a truthful person. So
Well, is that what Sarah's testifying, or sorry, Anna's testifying though? Okay.
I was gonna say, I thought it was a 608 thing. I was gonna say no because that's not a particular opinion. So it was a
Okay, right. No, and that's fair, right? So, I mean, let's just kind of address that, which is, Joy kind of says, well, what if this were 608? What if this were meant to be character evidence? I mean, and the answer is it absolutely wouldn't be admissible. And you're absolutely right, it wouldn't be admissible because it's not in the form of opinion or reputation. But the more important thing is it isn't about truthfulness at all. And so that's why you shouldn't be heading down that 608 road in the first place. So, okay. Rather, I mean, I think the best answer we have for how this is relevant is Kelly's answer. Kelly's answer? Yes, Kelly's answer. That it's relevant to show that she used the turn signal on this occasion and therefore did not run Derek off the road without using a turn signal, therefore wasn't negligent. Okay, so then what rules do we want to think about in trying to decide its admissibility for that purpose? And Kelly said 406. Why would we talk about 406?
Well, within the facts, it's saying that Anne is saying that Sarah is crazy about turn signals and that Sarah yells at her every time she changes lanes without using a turn signal. So it's trying to show that it's within Sarah's habit that she uses a turn signal all the time.
Okay. So we might think about 406 here because just the framing of Sarah's Anne's testimony is in sort of that repeated or regular response to a repeated specific situation. It sounds like habit evidence in that way. But here's what you need to think about with respect to habit evidence. I mean, evidence is admissible if it's relevant, right? And we've established how this is relevant. And habit evidence is kind of a rule that says, here's a kind of evidence that's admissible. But that's pretty unnecessary unless there's a rule that would otherwise tell us that it's inadmissible. So what rule tells us that evidence that looks like habit evidence might be inadmissible unless it satisfies the definition of habit? In other words, Rule 406 is an exception to another rule. What rule is that, Elizabeth? Yeah, 404A1 that says character evidence is generally inadmissible. And 404B as well, which tells us that evidence of specific acts for the purpose of establishing a trait of character to prove action in conformity with that character on a specific occasion is inadmissible. And that's the same framework, they're kind of the same general structure as habit evidence. You prove a bunch of specific acts in order to prove that on this occasion they acted in conformity with those actions, right? So the first place you'd probably want to start here is just a statement of, this is 404 evidence. This is character evidence. As in, it is evidence that would prove a trait of character, be it very specific, as in the craziness about turn signals or perhaps being a careful driver, offered to prove that Sarah was a careful driver on this occasion. General matter, inadmissible, 404A character evidence. However, it might be 406 habit evidence. Evidence of habit is admissible to prove action in conformity with that habit on a specific occasion. Habit is defined as a regular response to a repeated specific situation. Is this habit evidence? Joy?
I thought we said, level for habit, we said that it needed to be like proven like over and over again, and there's nothing that showed like that would show that that's actually what she did every time. But
Okay, so I mean, normally to prove habit, we need both a regular response, as in it happens every time or nearly every time, to a repeated specific situation. So we need that situation to arise enough times to say we have a habit, and we need it to be specific enough to say we have a habit. So do we have that here, Marima? Right. Even if this is habit evidence, even if this does establish a regular response to a repeated specific situation, the regular response being yelling at Anne and the repeated specific situation being Anne not using a turn signal, that habit doesn't actually prove what we need it to prove. That's the reason 406 doesn't apply here. It may be a habit, but that habit isn't a habit that came into play here. It's not Anne that was driving. It was Sarah that was driving. And so to the extent this is relevant, it is only relevant to show that Sarah generally cares very strongly about turn signal usage, to suggest that Sarah must have practiced what she preaches on this specific occasion. But that's just character evidence. And so it's not admissible for that purpose. Okay, so you would start with 404. This is 404 evidence. Then you would explain why 406 does not provide an exception, and then you'd say 404 controls here. The evidence does not come in. Okay, questions? Yeah, Haley? What about that? Well, but the problem is 405 only tells us how evidence that's admissible under 404 can come in. And here it isn't admissible under 404. Yeah, Russell?
You said you want to first start with 404 and then go to why 406 doesn't apply and then conclude with that 404 is the control here. Did I hear it correctly?
Correct. Okay. Other questions? All right. B. How is B relevant? Yeah, Marima? Okay, good. So kind of this initial piece of evidence that Violet testifies to, Derek was a happy guy with a great life, is relevant to show that Derek wouldn't have driven off the road intentionally. Right, okay, good. But of course, that's not the piece of evidence that's, okay. So what's the relevance of the question that's being asked? Okay. Okay, good. So yeah, if Derek had been arrested 5 days earlier on charges of child molestation, it would rebut the argument that Derek was a happy guy with a great life. Or perhaps instead of thinking about it, the sort of almost a double negative sort of approach to it, another way to think about it is it's relevant to show that Derek had a reason to kill himself, right? So what rules might matter here? given that being the purpose of this question. Yeah, Joy?
Can I ask a question before you?
Yeah, absolutely.
So I had that idea, but also, what is the fact that we wouldn't use the analysis of whether or not she can inquire, well, whether or not they can inquire about that, because to see whether or not she really knew him as a person because that's his wife, so we wouldn't go down that.
Well, okay, so that's a good point. So perhaps, certainly Violet's statement could be viewed as character evidence.
Yeah.
Is that kind of what you're saying?
Yes, because I'm saying, well, I think, because isn't it true that he was arrested? Remember the conversation we had about the whole Nicholson thing?
Sure.
And about being arrested to say, well, you as a witness really don't know this person as well as you think you may know.
No, I mean, I think Joy has a good point, which is the question and answer, the direct and cross-examination in Part B sounds a lot like what we've seen elsewhere in the context of character evidence, where a character witness can be impeached by asking questions of that character witness about specific acts that are pertinent to that trait to the trait of character they testified about. Why is that not what's going on here? Why is this not an example of character evidence and a question about a specific act? Or why is that less likely than our first articulation of relevance? Joy?
She's not saying it to say that he.
Well, I mean, but now that's a good point, right? I mean, Joy said she's not saying it presumably to provide character evidence, but of course, how evidence testimony functions, what kind of evidence it is kind of up to the attorney. Why can this not be character evidence? What did we just say in Part A about character evidence in this case? It's not admissible, right? Because this is a civil case. So character evidence isn't admissible. So Violet could not be providing character evidence. Violet has to be testifying for some other reason. Now, of course, then the question by Sarah's counsel is what we care about and what it's being offered as. But what rule might govern the admissibility of that question? What rule or rules might we be thinking about here? Any thoughts? Or is this just admissible? I mean, we've established some relevance for this evidence, in which case it is presumptively admissible absent some rule that applies. Is there any rule that might keep it out? Candace?
But I get that you're saying that it's like what Mayor was saying, Mr. Buddy, their argument. I thought it was more like impeaching her testimony because she's testifying to show that he didn't have a reason to drive away to kill himself and all that. And then they're asking if he was arrested for molesting somebody. That's like contradicting the fact that she's saying he was happy.
Well, right. I mean, no, and that's the same thing, just said in a different way, right? I mean, when we say that it's impeachment of her testimony about Derek being a happy guy with a great life, that's absolutely true. But of course, impeachment happens in a lot of different ways. And so for that to be a helpful statement, we need to say it's impeachment by showing that there was a reason why Derek was not a happy guy with a great life. Okay? That is a relevance, and I think that's kind of the same relevance that Miriam articulated, but just said in a different way. So both are right. Abigail? Okay, well, I mean, if we're starting from a position that this evidence is relevant, the next place we need to go is, how could this evidence then be excluded? Because again, it's presumptively admissible. So what rule might exclude it? I mean, now, oh yeah, Laura?
I talked kind of generally about 403 because these kind of questions or statements are not relevant and the danger of confusing the jury and would be too confusing for the jury, would cause, undue delay, time wasting, and even if it is relevant, the probative value isn't outweighed by the prejudice that it would cause.
Okay, so 403 might keep it out is one answer. Any other rule that might keep it out? That you might argue would keep it out? Wouldn't you argue 404? No, I said that obviously that originally Violet's testimony must not violate 404 as character evidence. But these are two separate pieces of testimony. We need to address each, we need to only address the one that we're asked about. We're asked about the question. And the question is, isn't it true that Derek was arrested 5 days before his death on charges of child molestation? Couldn't that very well be character evidence? Perhaps. Do we have an argument for it being admissible anyway, or not admissible anyway, but there being some relevance to it besides the character relevance, painting him as a bad guy in some fashion? Caroline? Yeah, sure, his intent or his motive, right? I mean, the initial point is there is a non-character use for this evidence. But you want to be clear that it's a non-character use. It is useful to show his motive to kill himself. Motive in a non-character way. I mean, this is a very specific motive, a specific reason why he might have done what he is claimed to have done. So that's our first issue. Then we would just move on to 403, as Laura suggested. Now that we've identified its relevance, its non-character relevance, we would say, how good of a motive does this provide for one to kill oneself? And of course, it's impossible to quantify such things, but you would want to just articulate best you can. I think this is a great motive. I think this is not a motive that would motivate people to kill themselves. Whatever. I mean, it's kind of all you can do. Yeah, person at home.
But didn't the first question open the door?
To what? Person at home. Open the door to what?
Like I have to cross-examine,
What's that?
like if we were to cross-examination.
Sure, but you can only, no, I think that's fair, right? Opening the doors, yeah, no, that's true. So opening the door typically means to cross-examination, I guess, except that still doesn't open the door to just any question at all. I mean, the fact that something was inquired about on direct doesn't mean any question can be asked on cross-examination. So we talk about probative value, and then we would have to talk about risk of unfair prejudice. What is the risk of unfair prejudice here? Bobby?
That they would kind of convict him for his prior crime of child molestation.
Right, or in this case, I think we, to kind of convert that criminal law sort of argument to this, basically, they think he was such a bad guy that they're glad he's dead, and they're not going to award any money for his death. Right? That even if Sarah were negligent, perhaps we don't want to punish Sarah because Sarah ultimately did a good thing by killing this child molester. I mean, that's the concern. And so then we would want to say, well, how much of a risk is there of that unfair prejudice? And then how do they compare? But of course, remember that when we talk about like quantity of probative value and quantity of risk of unfair prejudice, those are really hard things to quantify in a meaningful way. So what I'm mainly looking for in my grading of your analysis is that you can identify that probative value in as precise a fashion as you can. How is this probative? And that you can identify the risk of unfair prejudice in as precise a fashion. What is the risk that Derek's survivors will be unfairly prejudiced here? Joy?
You also argue that, like on the other side of what you were saying, that it was so dissimilar that the jury wouldn't be trying to hold him accountable for being a child molester because it was so different than.
Well, but remember, so when we're talking about character evidence in the criminal context, there's kind of two concerns we have. I mean, one concern is that prior bad acts of a criminal defendant will just make the jury think this is a bad guy who should be put away to keep all of us safe. And then there's the fear that they'll say, oh, somebody who did that bad thing in the past is must have done this bad thing here despite the facts. And you're right, that second kind of, I don't think that second kind of risk of unfair prejudice exists here. I don't think anyone is likely to think, oh, well, I mean, as we know, child molesters are likely to drive off roads and kill themselves. That's not really a fear that we have. We're not afraid the jury's going to think that. We're really just afraid the jury's going to think the first. This guy is such a bad guy, it's a good thing he's dead, and we're not going to punish Sarah for it. Okay? Other questions? All right. So let's finish up with part C. How is the evidence in part C? How is Arnold's testimony potentially relevant here? Caroline? Okay, right. So ultimately what this is meant to show is Arnold's testimony is meant to at least be some evidence that Sarah caused the accident here. How would it show that? Okay, and yeah, what does it suggest that she paid him to end that lawsuit? What does that suggest? That she caused the accident with Arnold. And what would her causing the accident with Arnold suggest about her liability here? That she caused the accident here, right? So that's the chain of inferences. That her paying out the settlement suggests that she was liable, in fact, in Arnold's case, which would then suggest that she is liable here too. That's our chain of inferences. What rules exclude that evidence? What's that? 404. Right, so 404 does, because the second part of that chain of inferences is character reasoning. It's essentially saying, because Sarah caused the accident with Arnold, Sarah must be negligent, which means that she was negligent on this occasion. That's classic character reasoning and not permitted. What other rule forbids this evidence from coming in? Huh? 408 also does. Because this is using evidence of a settlement of a claim to prove the validity of that claim, which is what 408 forbids. So it's using the settlement of her claim with Arnold to prove that she was in fact liable on the claim with Arnold. And so you'd want to articulate both of those. Vandela?
So it's not using the fact of Arnold's claim to prove that she was liable for Derek's?
Well, it is, but in order for the validity of Arnold's claim to show the validity of Derek's claim, you have to first show that Arnold's claim was valid, and that's what 408 doesn't allow. Good. Any questions? Great. Okay. So that now leaves us with some time to talk about question 3. What's that? All right. So like with bar-style questions, you begin answering law school-style questions. Kind of your first task is the same, which is issue spotting. But as before, with evidence questions, the first way to go about beginning the task of analyzing a piece of evidence is to start with, how is this evidence relevant? And some pieces of evidence, the relevance of it is more straightforward than with others. So we begin with, so we essentially here have 4 kinds of evidence, or I guess 3 kinds of evidence, and 1 slightly more open-ended question. The first one is a video. And I think here the relevance should be pretty straightforward. What's the relevance of the video? Or do you guys need time to read the question? Yes, take a couple minutes to read the question. Yes.
Because of both sides, don't do it. However, if it wasn't useful, he was more greenhouse.
Yeah, no, Danielle has a good question, which is on question 2, when we said something was inadmissible because it was character evidence, she asked, do you need to then say, but if a court would find it not to be character evidence, this is 403, blah, blah, blah. And no, you don't. You don't need to engage in that kind of alternative reasoning for every question. I mean, there is an element of judgment, right? Where if it seems like from the call of the question and the facts provided that there are 2 issues you ought to discuss, then you want to make sure you discuss both of them, but you don't need to feel obligated to go through the full analysis every time. All right, now read. All right, so question 3 is an excellent example of the sort of typographical errors that I will not, in fact, punish you guys for making in your own exam answers. But beyond that, we have different kinds of evidence, right? And we only have 15 minutes, so I'd like to kind of go through these relatively quickly, perhaps not discussing in great detail the substantive issues that underlie them, but rather thinking about them in terms of just issue spotting. What ought you be talking about as you talk about these different questions? So looking at the first, we have a video. What stuff do we need to think about as we think about the video? What general issues? Sean? Okay, authentication and best evidence rule. Those are usually good bets whenever you're talking about any sort of video, photograph, document, anything like that. Good things to think about. Authentication, certainly. I mean, we have a real question here about whether this is what it is claimed to be, which is a video of the altercation between Simmons and Pearl. Best evidence rule, I think you also ought to discuss, though probably the discussion will be a little less extensive. Certainly a good argument that if Pearl doesn't testify, this is being offered, a video being offered to prove its contents. But also it appears that we have, or at least there's a good argument we have the original to the extent it's authenticated. Okay, so those are 2 things. Anything else? Kelly? Okay, possibly 403 in what sense? What's the risk of unfair prejudice?
There might be, there could be possible time wasting, trying to assess exactly what they're saying in the video. Maybe some
Okay. So time wasting to the extent we need to discuss authentication and stuff like that a lot. What kind of confusion of issues do you foresee? Are you answering that question, Caroline, about confusion of issues? No, that's okay. I'll come back. I just kind of, do we have any confusion of issues? I mean, put yourself in the shoes of Pearl's counsel. What would you argue about confusion of issues? Vandela?
Well, she just has to show that she had a reasonable belief, but if you see a video with an unarmed man being shot, then they're not really, the jury's not gonna be really thinking about what her belief was, it's just the fact that she shot a man.
Yeah, and I mean, why does this video kind of exacerbate that problem? That they might just focus on this is somebody, an unarmed person being shot. Chelsea? Okay, although we don't know much about that perspective, right? I mean, you're right, it certainly could, but we don't have, I mean, all we know is what it shows. We don't have a good sense of that perspective. But I do think we have one bit of knowledge about the video that is telling for this issue. Laura?
Other than, you can't really, it doesn't say in the background that you can like exactly identify that the two people in that video are who they say.
Okay, but that's authentication, right?
But don't know who, you can't find who shot, who took the video.
But who cares who took the video, as long as it's authenticated as being a video of this event? I mean, and I'm not trying to be, but I think that I think those are two separate issues. Once we authenticate it, and remember, all we're doing is we're saying there's enough evidence for the jury to conclude this is a video of the event. Then you leave it up to the jury, where the jury, presumably, if they decide this video is not a video of the shooting, will ignore it. I mean, almost certainly they would. But I think there's something about the video itself that is perhaps problematic from the standpoint of our defendant here. Sean? Okay. Why is that a problem? Okay. Although that's not really unfairly prejudicial, because that's actually what happened, right? I mean, it may be bad for her, but it's not unfairly prejudicial. Tevin, what's wrong with this video? Yeah, right? We have no idea what happened beforehand. That's going to be the problem. That's going to be our 403 analysis. Is that, who knows, right? I mean, if I were her, I'd be like, hey, this only gives us really vivid evidence that the jury will put a lot of weight on of the part that we all agree happened, but not about the part that actually is in dispute here, which is what happened before the shooting, what might have justified it. So that, I think, would be part of our 403 analysis as well here. Yes? Well, separately, because they're separate issues, right? And I mean, that's kind of what I was trying to get into with Laura's question, which is, you know, we need to separate out this issue of, is this a video of the shooting versus is this unfairly prejudicial? And if it's authenticated, it's probably not unfairly prejudicial because the jury's either going to conclude this is a video of the shooting, in which case they'll pay attention to it, or they're going to conclude it isn't, and presumably no juror would pay attention to a video that's not actually of the shooting in question. So they really are separate issues. Yeah, Elizabeth?
If you don't know who shot the video, does that have anything to do with the compensation cost?
Okay, so that's a good question. So is there, and that kind of also is one of hearsay. So I've talked to some people who raise hearsay issues with respect to the video itself, because we only care about confrontation anyway with respect to if we have hearsay. Is the video hearsay? And this is a somewhat difficult question, but one that I think I can give you an easy answer to. The easy answer is no. A video isn't hearsay. And we can kind of talk about it in a little bit more detail if you want. But as a general matter, shooting a video is not an assertion of any facts. It is a recording of events. Now, I understand you can make an argument that shooting the video is an assertion that these events happened, but it really isn't. I mean, shooting a video is not asserting that the events in the video happened. It's simply making a recording of the events that through a mechanical device, which is different than, say, writing a story about events that happened. That's actually an assertion. Sean? I think here, I don't know that the posting of the video is a statement. The posting of the video with this specific title is a statement. I think the titling of the video is the statement here. And that we ought to think about in terms of hearsay and in terms of confrontation clause if we decide it's admissible hearsay. Russell?
We obviously haven't had a case like this.
Uh-huh.
And so we're kind of treading into waters that we haven't really explored. How much weight is going to be given to an answer that may not explore it as fully just because we're kind of unsure of maybe where to go?
Okay, so it's a really good question, right? No, and that's a great question, right? And you're right. This is an issue we have not explored in class. And those of you who had me for criminal law may be familiar with the idea that that's what I do on exams. Okay? Because part of my goal, I think, is one way that I test you is to see how you deal with applying the rules that we've learned in class to somewhat novel situations. Because that happens in real life, okay? And I want to see you do the best that you can. And a bad answer is one that doesn't recognize that what you're doing is hard and that it's not certain what the answer is. You know, is assuming that, or kind of taking the position that, uh-oh, here's a situation I don't know how to deal with. I'm going to act like it's really easy and just give a really basic, straightforward answer to it. That's not a good approach to take. A better approach to take is one that at least recognizes that what you're doing is a challenge and that you're not exactly sure how to answer the question. And that's okay. But I want to see your thought process. I want to see you wrestling with it. And if you wrestle with it and come up with an answer that isn't right, that's better than not wrestling with it at all. Obviously, the best thing is wrestling with it and coming up with like some fully awesome, well-developed answer that pulls in policy and reaches some conclusion where I'm like, holy cow, you're absolutely right. That's great. But I also, look, I wouldn't expect that out of myself on an exam, and I'm the professor, okay? So I know what I want to, but I want to see you trying your best on a situation like this, which is not something you've seen before. I hope that answers your question. Okay. Yes.
Posting the video is an assertion because it is communicating to the audience of people on the web.
Well, it is a communication, but it's not clear to me that it is an attempt to communicate a fact to an audience outside of the fact being communicated by the title. The titling is a fact being communicated to the audience, but it's not, I don't think that the video is a fact being communicated to the audience. But I can see the argument, okay, maybe the counter argument is, yes, it is. It's an assertion that this event occurred, and that is being conveyed to the audience. Nevertheless, videos are not hearsay. See, that's the easy answer. Videos are not hearsay. There are harder levels to that question. So, and because they're not hearsay, their confrontation clause also doesn't apply to them. Okay, so that's part A. We can talk more about it if you want in my office or on email or whatever. Okay, B, admissibility of expert testimony. This is the kind of question where you ought to have a framework coming into the exam on how to answer questions like this. And that framework, ideally, looks a lot like the framework we undertook when we looked at Marissa Tomei's testimony in our video during class, right? So you ought to go through, do we have proper qualifications? Are we okay with the topic of these opinions? Are we okay with the basis of these opinions? What did he look at in formulating these opinions? Are we okay with the methodology? Is it relevant and is it reliable? All right. So that's the analysis I want to see you undertake. Again, we can discuss that further outside of this review session. Well, I do want to step back real quick and say something about Part A, right? Part A is more your typical sort of analysis. Start with relevance, go through substantive issues, finish with 403. Part B, you don't need to spend much time on relevance. I mean, the relevance is pretty straight, it's pretty obvious. It's to show what the opinions assert. And so you want to spend your time more on what these specific rules are. And even 403 in this case probably doesn't have much of an analysis. C takes us back to another problem, or is a problem that takes us back to that basic framework, really with a lot of emphasis on that first part. How are these past convictions relevant? Sorry, I framed that like it was a rhetorical question. But I mean, what are your thoughts? How are these convictions relevant? Oh, and somebody has asked me, should these convictions be addressed separately? And I mean, my general answer to a question like that is yes, if the analysis is different. My specific answer here is yes, because the analysis absolutely should be different, because they are relevant for different reasons. So how might these be relevant? How might the simple assault conviction be relevant here? Sounds like somebody's receiving a Morse code message on their phone. But anyway, how is the conviction for simple assault relevant? Ashley? Okay, yeah, right. It would show that he's potentially violent, right? Or perhaps even more specifically, violent towards women. Okay. How else might it be relevant? Joy? Okay, disregard for the law, a willingness to engage in unlawful conduct. Fair enough. It also might be relevant, and certainly if Pearl knew about it, it might be relevant because it might establish in her mind a more reasonable fear of him. Now, of course, it is not going to be admissible, at least for those first two reasons, right? To the extent that it's offered to prove that he's a violent guy, that's just character evidence. Wait, but is that admissible? No. Is it? Is this the kind of case where it's admissible? Is this a criminal case or a civil case? Criminal case. So might it be relevant? Yes. So perhaps it would be relevant if she offers it. So we'd want to talk about that. Okay. So, and then we would have, but would it be relevant? Would it be admissible? 404A2 does permit evidence of a victim's pertinent trait of character. Is this admissible as that? Certainly fits under 404A2B. The problem? 405. This is a specific instance of conduct being offered to prove character. That's not allowed. Evidence of character must be proven on direct through reputation or opinion. Not okay. Okay, so you'd go through that analysis. For the second part, how is the second part relevant in a way that's different from the first? How might the resisting arrest conviction be relevant? Danielle?
But 404B, it shows a motive because maybe change your emphasis. Since the previous altercation with blinding police, since protesting the police, they lacked respect for the police, and then he had a reason to get into the altercation.
Yes, absolutely, right? This would arguably be evidence of motive or intent, a reason why he might have engaged in the conduct that Pearl is arguing he did, why he might have resisted arrest. Okay, Russell?
Resisting arrest also be evidence of lightning? It's not necessarily a chase.
Okay, and so what does that mean? Well, I mean, why? Yeah, how? Okay, except here we don't have evidence. I mean, to the extent we have evidence of flight, as in perhaps he resisted arrest by trying to run away, we don't have some other crime that we're trying to prove his guilt of. So it doesn't quite work there. No, rather, this is a different conviction because it might prove something that isn't character evidence, and we'd want to talk about that. So kind of just a good lesson, I suppose, is anytime you have a problem like this where you're dealing with two very similar pieces of evidence, you want to be thinking about them in relation to each other, right? How are they different? And articulate that. I mean, presumably there's a reason I'm asking you about two different convictions. There is some difference that you want to be thinking about and might want to explain or explore in your answer. Danielle?
I have a question about your first conviction.
Okay.
Mm-hmm. I recognize that, but I like said the questions could be asked in this way to bring it up as a petitioner opinion. Like, do you know if this person is a violent person? And then the response would be yes, but not saying because of the domestic violence. Like, would that still answer the question, or would it be?
No, that's fine, right? So Danielle's question for those listening at home is whether or not, talking about how you might make the first conviction admissible as opinion or reputation evidence is worthwhile as part of your answer. I'll not answer it in this way, which is to say, obviously, the more connected what you say in your answer is to the underlying question, the better. So you want to spend more of your time talking about the admissibility in a more direct fashion. But if you have time and you want to discuss that, absolutely, right? I mean, feel free to kind of riff, for lack of a better term, on a law school style essay about that kind of stuff. Okay, so we are complete, done, but let me just get to discuss number 4, or part D. Part D is what happens when I want to discuss an area of the law, but I don't really feel like actually generating any sort of hypothetical about it. So instead, I just ask you to explain to me how the rules work. That's all I've done in part D. I've asked for your explanation of how rules of impeachment or rebutting of character witnesses work. And so I would want you to step through the ways that one can rebut or impeach a character witness under the federal rules. Yeah, I know that's kind of a jerk move on my part because nobody asks questions like that. But it's not asking for anything beyond that. I am really just asking for you to just step through how the rules work, the different rules that apply and how they function. So I'm happy to talk about that with you. It is kind of you will not see a question like that on any of my other exams. I'm not saying I will never create another question like that, but I'm not saying I will. So, but it is a unique kind of question. So, yeah, sorry. All right, cool. Thank you all for coming. Thank you all for watching. And great. I strongly encourage you, please. I have plenty of meeting time still available over this week. I strongly encourage you to come in and see me as you develop questions as you go along. Thanks. Oh, yeah, Russell. Oh, that's right. I stink. I was supposed to show that to you during this review session. I'm not going to tell you. That's like cinema, man. I'm not going to spoil the ending. So I'll tell you not in this. I'll happily tell you. And man, I'm trying to think of any way that I can satisfy your curiosity for what happened at the end. It's still on Netflix. It's certainly worth streaming. Yeah. Yes. Sorry. I'm a terrible human being. Thanks, guys.